Finally, it seems, an end to Walter Onnoghen's case. The Code of Conduct Tribunal has ordered the forfeiture of 5 bank accounts belonging to the former Chief Justice of Nigeria. And then we have Atiku and the tale of the INEC server. Atiku Abubakar has defended his claim that he got the results of the February 23 presidential election as tendered in his petition from the server of the Independent National Electoral Commission. This is Plus Politics, and I'm Felicity Ezewike. Now, the Code of Conduct Tribunal, CCT, has convicted the embattled Chief Justice of Nigeria, Walter Onnoghen, after finding him guilty of false asset declaration. The tribunal, headed by Danladi Umar, ruled that Mr Onnoghen should forfeit the funds in the 5 accounts which he was accused of not disclosing, banning him from public office for 10 years. Joining me now to talk about this and other development is legal practitioner Obi Adjegbo. Thank you very much for coming in. And of course, we have Dr. Kubi Odofia. He's also a legal practitioner, 2 legal minds. Thank you very much for coming.
Thank you.
So I will start with you first, Obi. What does this judgment mean?
Well, we've all been expecting a conviction.
Really?
Yes, we've been expecting a conviction after the first pronouncement of the Code of Conduct chairman saying something to the effect that the CJN was trying to, was bringing an equal submission to avoid punishment, which means the verdict had already been written.
So what are the implications of the judgment?
Those are very good grounds for appeal.
Okay, you see it going to appeal.
It must go to appeal.
Well, the attorney to Onnoghens has actually said they will be going further to appeal the case. But before we get to that, let me come to you and ask this seemingly pertinent question at this moment. Can somebody who has resigned from office, as Onnoghens has done, be sacked from that same office? What does this mean?
Yeah, I think it's an interesting scenario because if you look at the relevant provision of the Constitution, where a public officer can resign from office, it actually provides that resignation takes effect when the appointer receives the resignation letter. So the appointer need not do anything, maybe accept or reject resignation. And we know on good authority that Justice Onnoghen had sent his resignation. So it became effective by operation of law. In the eyes of the law, and this is my opinion, it is assumed that he had resigned and ceased to be whether you call it acting CJN or CJN. So in the light of that, my opinion is that the subsequent order for his removal is merely academic, though it has other implications. For instance, I mean, that's just one part of the judgment. I mean, 3 orders were given. He has to forfeit accounts. I mean, his money in the 5 accounts he did not declare, and he's been barred from holding any office for the next 10 years. I mean, those are grounds he has to appeal. And although it's academic, I know his lawyers have also indicated, interest in appealing, which is quite important, if not for anything, to clear his name and to set the record straight. And in any event, it's also good in terms of developing our jurisprudence. So I think, for me, it's merely academic. This guy had resigned, so he can't be removed from office. Yeah, and even if he was to be removed from office, he has sent a resignation. Okay, the NJC, let's look at it from another perspective. On, I think it was April 4th, the NJC sent a recommendation to the president, which was not disclosed.
Yeah,
but we got to know that
this is not protocol. They usually tell Nigerians what their decisions are. So in this case, they did not.
They did not, because
they've not also made a reaction as to whether they accepted Onnoghen's resignation or not.
Or not. No, his resignation was meant to be, he sent his resignation to his appointer, the president, which is the proper thing to do. But coming back to the NJC, they have sent a recommendation, which the contents were not disclosed. Like you said, it was not disclosed. The NJC explained that this was a special circumstance they were were dealing with the #1 judicial officer, so they needed the president to see the contents first before making the disclosure. And the procedure would have been if the president accepted, because we heard that the recommendation was actually for him to be retired. So the president was now meant to send that to the Senate, and the Senate would maybe address by 2/3, make a recommendation which the president will now approve. That's what the Constitution provides for. So nothing was done. The president delayed. He has not done anything or revealed the contents of the NJSC letter till date. So that remains a recommendation. Nothing has been done. Whatever was recommended is now merely academics. Because in the eyes of the law, the acting CJN or the CJN had resigned some days ago.
Yeah, but the CCT ruling, if we're to go by the argument that has been put forward before now, that it is only the NJC that has the responsibility to discipline, so to speak, judicial officers that misbehave in the course of their duty. And now we have the CCT ruling, and Onnoghen actually actively participating in that. Doesn't that place the entire setup for ordinary Nigerians? I believe it would be a bit confusing. Yeah. Let me come to Obi, and then you can.
Sorry, before I answer that, remember Justice Ademola?
Ademola.
Yes.
He resigned.
He resigned, and then
he resigned when it was imminent he was going to be sanctioned, so he resigned.
So he resigned, and then the NJC sacked him.
Even after he had resigned?
Yes.
Okay.
Yeah, I think the excuse then was that he communicated, they actually acted before he resigned. That was the argument. So his communication resignation was belated. They said they had taken the action even before they received his resignation.
So that the scenario does not
Yeah, it can be distinguished to an extent.
It can be distinguished, but the scenario I understood was that a few days before they announced his retirement or his sack, he went public that he
got wind of it and then went public
he
preempt
sent
them.
a letter of resignation, but eventually it was the NJC's action that took preeminence.
Okay, so can you speak on the disciplinary actions of the NJC? They're supposed to,
It is the NJC that has the power to discipline, to retire, to appoint, and to do everything. NJC working with another body is another body that does the appointment to do that. But we are really shocked at what is going on now. Very shocked.
What are your thoughts on
that? I think it's quite absurd because the authority is FRN and Nganjuwa and FRN. Nganjuwa was a justice of the Court of Appeal. So the decision was that, the decision of the Court of Appeal, that before a judicial officer is subjected to trial, he must have passed through the relevant disciplinary procedure by the NJC. And subsequent to that decision, this same CCT, as at last year, I think it was May 15th, Justice Sylvester Nguta, a justice of the Supreme Court, was being prosecuted at the CCT. So based on that decision in Nganjuwa, what the CCT did was they quashed the charges and discharged Justice Sylvester Nguta. That was 15th of May last year. But today, there was a sudden turnaround. There was a preliminary objection by Justice Onnoghen saying that the CCT had no jurisdiction to try him because he had not gone through the disciplinary procedure of the NJC and had not been indicted.
That was dismissed.
Yeah, it was dismissed. And what the CCT did today, for me, was a mere hair-splitting, distinction without a difference. They held that this case was different. In fact, they expressly overruled itself. It expressly overruled itself. Decision of last year. They held that in this case, Section 158, which mandates NJC to discipline judicial officers before they are tried, was not applicable. Why? Because in this case, Justice Onnoghen was being tried as a public officer, not a judicial officer. That's mere hair splitting. You ask yourself, what makes him a public officer? He's a public officer by virtue of being a judicial officer. But like my colleague here said, the whole thing was scripted. The end game, end result was to ensure that this man is convicted.
So is CC, if you're saying they're academic, their submission, the ruling today, wouldn't it be implemented? Doesn't the president have the responsibility to implement this ruling, or is there any other option available in this case?
No, I said it's academic in the sense that from three orders were given, like you mentioned, or like I mentioned before. The first is for him to be removed.
Yes.
That was the part I said was merely academic because he had already resigned in the eyes of the law. He was nobody acting or CJN or, But there are other parts of the orders which can be implemented, like stopping him from holding public office for the next 10 years. One can argue, well, he's resigned. But don't forget that judicial officers, from time to time, they can be appointed as chairman of panels, INEC, commissions, and so on and so forth. And then he has monies in 5 accounts that are also meant to be forfeited to the federal government.
Yes.
And I'm sure these are his savings, his life savings. And more importantly, I'm sure Justice Onnoghen will want to clear his name. So
I'm sure he would.
Yes, so it's not merely academic in that sense.
Yeah.
Yeah.
What you were saying just reminded me of what you said earlier, that there's a possibility, or was it you, that he might miss out on his pension. This is somebody that has served the country for quite a number of years in judicial capacity. What is the implication, aside from losing his name, what other possible implications are there for Onnoghen as an individual?
Yes, like I said before, I mean, there are reputational issues. For now, he's an ex-convict or a convict. Because, yes, sorry to say, it's a valid decision. No matter how much we can criticize it, it remains valid until it is overruled by an appellate court. So that fact remains that there are reputational issues. The first CJN to be removed from office and to be convicted after being removed. That's if he was actually removed before he was, before he left office. And I mean, he's losing his entitlements. He's barred from
earning money.
He's also barred from, because there are other entitlements that come with it, like sitting in the, what do you call it, State Executive Council?
Is the crime commensurate with the punishment?
It's a crime commissary. It's not a crime in this sense.
Is there a crime?
It's not a crime.
What it is, if there was no breach of some procedural, that is what it is.
Can I take you back?
Okay.
When you remember the cross-examination of the witnesses, the accounting officer gave details of the sums of money in his account. And I was really surprised when I read now that they found $1 million or $3 million in there. So it doesn't add up. On the merits of the case, he should not be convicted.
That is your opinion? That
is my opinion, based on that thing. And I was really surprised when they did not give him the no case submission when he did not succeed.
Do you see this case making headway at the appeals court?
Yeah, it'd be interesting because already his lawyers they've indicated interest that they're going to appeal. So it'd be quite interesting because at the Court of Appeal, like I mentioned before, there's a pending judgment, a valid judgment, Ganjiwa and FRN, to the effect that judicial officers cannot be tried in conventional courts unless they've gone through the procedure on that section 158, meaning that they have to be disciplined, by the NJC. So we're waiting to see if the Court of Appeal would also overrule itself and decide differently. So it's going to be an interesting scenario. And that's why we're thankful that Justice Onnoghen would have the opportunity of vesting this decision at the Court of Appeal and perhaps at the Supreme Court.
And also, Justice Onnoghen will now be on the receiving side because a few people go to collect dates from the Court of Appeal and they're given 2020, 2021. So let us see if that will apply to him too.
All right, let's look at it from another perspective. This ruling has come now. Expectedly, we look to see a possible appeal later on, but there is still a situation. We have an acting CJN whose tenure expires in a week's time. What happens after that? What are the options available? Let me take that question to you, Dr.
Okay, I think what would happen, because the law is clear, being in active capacity, the president has no powers to extend his tenure, except on the recommendation by NJC. So I know the NJC, they were meant to have a meeting today, one of their first non-emergency meeting in many weeks. So it is expected, because the speculation was that in their recommendation to the president, they had given him a clean bill of health, and it was just a matter of time before he's confirmed as a substantive CJN. So the belief is that they have two options now. It's either the NJS who would recommend him to the president so they can extend his tenure pending when he's confirmed, or they can recommend his confirmation, but that has to be done before the 24th of April because that's when his tenure in active capacity would end.
Do you see all of this happening before
It's likely it's going to happen. I mean, if it doesn't, then we'll have a constitutional crisis in our hands. But I believe they'll do something about it before the 24th of April.
Are you sure it wasn't recommended
memo that we didn't see.
that was sent to the president.
Yeah, but then we'll be in the realm of speculation. Like I said before, the president has, a chunk of the blame in this. I mean, the recommendation was made to him. Till now, he's been mute. Nothing has been done.
He's not been
I was going to ask you another question, but what you just said now is prompting me to ask that the way this whole situation has unfolded, the executive and the way they handled the situation, do you think that there is a way they could have done this properly so it doesn't get this seeming backlash, not only from Nigerians, but from scholars who have been in the judicial system for a while?
Absolutely. I think they got it wrong from the onset when they got the strange ex parte order from the CCT. I mean, let's leave the substantive issues of law, let's leave that aside and look at the procedure in which, they carried out the trial. It was all faulty, all flawed. I mean, if it was meant to be an anti-corruption war, they would have ensured that they followed the right process, due process of the law, so that the ordinary Nigerians or all will see that justice, not only see, but, they'll believe and feel justice being done. But they got the procedures wrong. The funny ex parte order they got, bad precedent, and now it's a new dawn. Like I told my colleague, before now, it's a new dawn. A dawn where we have a culture where judicial officers can easily be intimidated. A culture of, ridiculing.
Is it a culture? Because some people, there are those who argue that this is a win for the anti-corruption fight in the judiciary. Because we've had several cases of corruption.
It's not. I totally disagree.
It's just intimidation.
The procedure was faulty, completely and totally faulty.
They should have gone to NJC first.
The president had no powers to suspend the CJN.
But they tried distinguishing. Attorney General that is supposed to be guiding the presidency in certain action. Do you think that he failed in his responsibility in this instance? Because they are supposed to know better. Probably,
because at the end of the day, he's an appointee of the president. His opinion is not binding on the president. So the procedure, like I said before, the procedure and the process, they were all faulty, and that has made the whole thing very tainted. The notion is that, look, this man is being given a bad name to hang. Let's forget about whether the substantive issues are right. But the process, it looked as if it was a script that was well written and had to be executed by all means. All forms of objections, whether they were valid or not, were overruled, and the CCT just had to come to this conclusion irrespective of anything. So they got the procedure and the processes very wrong. And that has tainted the whole process, the whole judgment, the whole conviction.
It's giving it a political context instead of an anti-corruption war.
Well, what do you make of Onnoghen's response in all of this and the defense that he has put up? Well, we do know that at some point, when this whole thing started, he talks about forgetting to, file that particular form. And while the prosecution is using it as a sort of confessional statement, his defense team is saying that that does not amount to a confession. Coming from there down to this judgment today, if you were to assess the work that this defense team did, how would you look at it?
I think they did their best, but I think now it's still early days to comment on the substance of the suit, like substantive issues, because we've not seen the judgment. Most of the things coming out from the tribunal are things that are being reported to us. But I think he tried his best. Initially, I know he was reluctant to appear, but at some point he had to appear, subjected himself, to the jurisdiction of the CCT. He had some appeals that were overruled, and some are still pending, which are now merely academic. And I think he tried his best. And thankfully for him, he still has the opportunity of going up, to the appellate courts to test the decision of the CCT.
Yeah, if you were to be, okay, let me not say if you were to be president, because that might be overstretching it a little, but based on your background and what you've seen so far from this administration, what possible responses would you expect to see from the president? Let me come to you.
The president, first of all, he'll keep quiet, and then his men will work, and their aim is to see that Onnoghen is convicted and is removed and disgraced.
What about you?
Yeah, I think the president, for now, if I were him, I would exercise some bit of restraint. The intention was to get this man out of the way. He's resigned. Let the law take its full course. Trial is still, he's planning to appeal. Let the appeal process go on. And then maybe confirm Justice Tanko Mohammed, because that's what they wanted, and then move on with life. And let the appeal process go on independently. Mistakes have been made, but it's not too late to ensure that the appeal is more transparent, and then, yes.
After the Court of Appeal, there's still the Supreme Court.
Because whoever loses
do you see the case getting to the Supreme Court?
It will, because whoever loses at the Court of Appeal will want to appeal. I mean, it's going to be like an ego issue, just to show that, look, I was right.
And then in the interim, what happens to our judicial system? Because we're talking about the highest office in the land. Will we have a solution, at least on the one side, why this case is pursued, or we're going to have some sort of confusion?
I can assure you that the NJC will sort it out.
But they seem to have been sort of quiet in all of this. First off, they came out with a report that they did not allow Nigerians to see. You cited the sensitive nature of the issue, but considering what we have on the ground, now we just have 1 week to knowing who is going to be. I mean, would you say that the NJC have handled this issue the way it should?
I think they have. I think they were placed in a very difficult position. Again, I mean, one would accuse me of blaming the presidency for everything and anything. But I think they were placed in a very precarious position because of the way the presidency went about the whole thing. I mean, they were kind of blindsided because this guy was removed. The CJN acting, or the immediate passing CJN was, effectively removed even before the NJC had the opportunity of acting. And what they had to do at the end of the day was just like a face-saving measure and damage control. Damage control. So everything had been done before they came in. And I think they acted well, and they showed a lot of maturity by not even disclosing the contents of their recommendation. And again, the president mismanaged that by remaining mute days and weeks after the recommendation had been made. So I can't really fault the NJC, I mean, in relation to their role in all this.
There's this accusation that most lawyers are biased in this matter, and their representation of what is going on is skewed towards supporting Onnoghen because of the fact that they're, they work in the same environment. How would you react to that? Let me come to you first.
I would not say we are biased. We work on facts. And the facts before us and the judgment we are getting, it doesn't tally.
But it's the same lawyers on one side, lawyers on the other side, arguing and saying it's the same fact that was presented to this person, that was presented to the next person, and the argument remains that,
some lawyers feel that the Aegean's table in the judiciary should be cleaned up. And they see any fight, no matter how ruthless it is, as an attempt to clean that up. But my take is, do everything constitutionally. If you know this man's tool, follow the procedure. Go to the NJC. From the NJC, let the NJC write a petition to the NJC. The NJC gives their decision, then you take it from there.
Do you toe the same line?
Yeah, but I don't think lawyers have been biased in this. And to be even fair to lawyers, I think lawyers have been divided. You have lawyers who are in support of what is going on presently, and you have those who are stoutly opposed to it. And I mean, I'm stoutly opposed to it. And most of us that are opposed to it, we're not looking at the substantive issues, whether he was right or wrong. We are only saying that due process should have been followed. And because due process wasn't followed, it's left the whole thing tainted with, illegality, marks of illegality, that, I mean, someone somewhere just wanted someone to be out, political witch hunting and all that. And I think if more lawyers are opposed to what's happening, it only shows that, I mean, based on our training, I mean, we are more enlightened legally, and so we are sticklers to procedures. You cannot separate or totally ignore procedural law from substantive law, because you get to reach the substantive issues, to reach the right decisions through following procedures. These procedures must be followed before you reach, your conclusions on the substantive issues of law.
All right, before I let you go, one quick word on what lessons should we learn from this whole fiasco of a city?
On whose part?
Holistically, what lessons should we take away, pending what happens after now?
Well, one thing I learned from it is that the NJC is a solid body.
Okay, quickly, you.
Yeah, I mean, it's just, I'm just sad about what has happened. It's, like I said, it's the dawn of a new era. Era of where the judiciary will be subject to fear and ridicule.
Intimidation.
And then tenure of judicial officers are no more secured, subject to the mercies of the executive.
Thank you very much for coming, Obi.
Thank you.
We appreciate your presence, and thank you too.
Thank you.
We'll take a short break, and when we return, we'll be looking at the former Vice President's petition against INEC. Stay tuned.